Hello and welcome to this Tutor to You example analysis on the Supreme Court ruling on sex in 2025. This video will help you work out how you can use this example in your essays, as well as its implications on UK law. So the Supreme Court ruling decided on the legal definition of a woman. Lord Hodge read out the statement where he said the unanimous decision of this court is that the terms woman and sex in the Equality Act of 2010 refers to a biological woman and biological sex. So this was decided by 5 judges. So not the maximum amount of judges available, which is used in kind of cases that seem to be more tricky and more difficult to discern, but actually a smaller number of judges decided this, which I think is interesting in itself. And effectively what this means is the Equality Act is seen to define trans women as excluded from some groups in single-sex spaces. So this can include things like women's only changing rooms, homeless shelters, swimming areas, and medical counselling services provided only to women. So it limits the access of trans women by defining what a woman is in the Equality Act of 2010. He does go on to say, though, and he gives a kind of warning here, where he says later in the statement, "But we can counsel against reading this judgment as a triumph of one or more groups in society at the expense of another. It is not. The Equality Act gives transgender people protection, not only against discrimination through the protected characteristics of gender reassignment, but also against direct discrimination, indirect discrimination, and harassment." So the First Minister of Scotland responded saying that the government accepts the judgment, and the government said that it will be engaging with the UK government to understand the full implication of the ruling. So it's interesting to see here, even beyond looking at Supreme Court and their kind of power within the UK Constitution, but also how this works with devolution, in the sense that this is basically forcing the Scottish government to overturn its own legislation and kind of redefine what is meant by a woman in Scottish law. So this case is called a landmark case. It's a landmark case because it establishes a new legal principle which changes the established interpretation of existing law. Essentially, the Equality Act had been defined to kind of protect characteristics, and protect one of those characteristics that are protected is being a woman. So protecting women from discrimination. And the Scottish Government had been using this to say, well, no, trans women are women and therefore must be protected as women too. So they were equal to women. Now, this marks a change in UK law because here we're saying, well, actually, trans women are not women. They are seen as something separate. They're still protected by their gender reassignment, but not fully accepted as women. So this changes the access to services and things that trans women can take advantage of. Now, it doesn't include Northern Ireland, and that's because Northern Ireland does not have the Equality Act. So it's changing UK law except for Northern Ireland. It's interesting as well because all public bodies are expected to update their policies by summer 2025. So within a few months, we're going to see more public bodies updating their policies to say, well, how does this affect their policies towards trans women in particular? So separating the two identities there. So how did we get to this point? And I think it's important to remember that the Supreme Court doesn't propose laws, but it can amend definitions of laws or definitions within laws, as well as declare law incompatible with human rights or beyond powers of the Constitution. So in this case, what the Supreme Court has done is amended existing parliamentary legislation. So what are these legislations? Effectively, this kind of begins with the Gender Recognition Act of 2004. This is an important act for trans people because essentially it meant that trans people could be treated according to their acquired gender for all purposes. And it created something called the Gender Recognition Certificate. We've seen the Scottish Parliament has been kind of amending this as well to try to make this easier to achieve for people who are trans and things like that. So this is a law that was established by the UK Parliament in 2004, but it's still a law that's very relevant and still widely used today. So this law is important in basically giving trans people rights and protections. Again, in 2010, we have the Equality Act. So this is a very important law for upholding equality within workplaces, public areas, as well as public bodies and so forth. And this law is incredibly important for protecting individuals from discrimination based on 9 protected characteristics. And as you can see here, gender reassignment and sex are both part of these 9 characteristics. And effectively, what the debate has been is in trying to fully define what is meant by these different characteristics. So you have the right to be protected from discrimination if you have gender reassignment, but you also have the right to be protected from discrimination based on your sex. So how does this work? Well, if we're going to respect gender reassignment fully, then that would mean it would come under sex, which is essentially what the argument that was made by the Scottish government. So within the confusion of these definitions, the kind of lack of guidance and guidelines, what ended up happening was, as much as the Scottish government was trying to drive through legislative change to be more inclusive towards trans people, some people in Scotland felt that this wasn't fair, and this group called For Women Scotland, which is a pressure group, essentially challenged the actions of the Scottish government. And eventually they bring this all the way up to the Supreme Court. And their point that they were making is that you can only be born a woman, and they do not agree that it is possible for someone to change gender and so forth. So who are For Women? And this is just to show you another great way that you can use this landmark case, because it shows the actions of a successful pressure group in making changes to legislation. So this is from For Women's website, and they're defining what their aims are as a group. They've been a pressure group for about 6 years, so to achieve this much change in 6 years is quite commendable. So they're a rights-based pressure group, and they advocate for women's only spaces to be only for cisgendered women, so women who are born as women. And they essentially look to promote rights and interests of women in Scotland. And this last bullet point I think is particularly interesting in this case. And they said, "We believe that there are only 2 sexes, that a person's sex is not a choice, nor can it be changed. So women are entitled to privacy, dignity, safety and fairness. Our legal rights should be protected and strengthened." So those are their aims. So basically protect women's only spaces for cis women. So those are their aims. What are their tactics? Essentially, these are the 3 main tactics that they deploy. One is consultations and oral evidence to parliamentary committees. So they act as experts, delivering evidence based on their own experiences or people's testimonies of how legislation can affect different groups of women and so forth. They also raise awareness. So they have things like marches, debates and things like that. And in this case, what we've seen is them successfully using judicial review. So judicial review is about trying to change the law through the courts, asking the judiciary to review something and arguing it's incompatible, in this case, with what they believe to be their human rights. And the law that they brought to the Supreme Court, arguing that this goes against human rights, was the Gender Representation on Public Boards of Scotland Act of 2010. So effectively, this law aimed to ensure gender balance on public boards, making it so that public boards in Scotland would have to be 50% men and 50% women. So they had initially attempted to challenge the definition of a woman in the Scottish courts, but after failing, they took this to the Supreme Court. So we can see here how the Scottish courts have a level of autonomy in looking over law and saying, well, no, it's fair for trans women to be included as women and to benefit from the Gender Representation on Public Boards Act. And they were rejected by the Scottish courts. And then they brought that case to the Supreme Court, so escalating it to the highest court in the United Kingdom. So they effectively argued, and this is a quote from Miss Spudge, one of the kind of leaders of For Women, and she said this. She said, "Not tying the definition of sex means that public boards could conceivably comprise of 50% men and 50% men with certificates, yet still lawfully meet the targets for female representation. So we can see it's quite catastrophizing what she's saying here. It's quite divisive what she's saying too. But this is the point that she brings forward to the Supreme Court, saying that this unfairly disadvantages women and that they need to have a full definition of what it means to be a woman in the Equality Act. So asking for clarity in that legislation and, in her perspective, making it so that women are defined as the sex that they're assigned at birth and limited only to that. So what we're seeing here is a pressure group that has had a tremendous impact on society in the sense that they've actually managed to change a law. So this brings us back to further things within our A-level politics studies, which is the issue of pressure groups and democracy. So is this tyranny of the minority? What gives them the right to represent how women are feeling about this, right? So what gives them the right to call themselves the representatives of women? So I thought it'd be interesting to see, well, where has their funding come from? What are their memberships? What gives them the legitimacy to bring this forward? And I essentially found that there is no clarity on the funding of this pressure group or how much money the pressure group has. So they're registered as a not-for-profit charity, and they are not aligned to any political party and are all volunteers. So still no clarity on that. In terms of membership numbers, it's also not stated on their website. It's hard to find. And I've seen with their demonstrations and so forth, they've had no more than 400 people at those demonstrations. So what then is it that gives them the legitimacy to say that they are for women, that they have the right to represent the interests of women in the highest court of the land? Because, of course, this Supreme Court ruling has an impact on a wide group of people, particularly in this case on trans women. So this is an extract from Dr. Michael Foran, a lecturer in public law at Glasgow University. And he essentially says that the decision itself is attempting to answer a question about what the meaning of the word sex, man and women, mean in the Equality Act. And he said the Supreme Court has resoundingly and unanimously said that the words man, woman and sex in the Equality Act are tied to biology and not gender recognition certificate. So it's putting in the limits of the GRCs here. And he again stresses that does not mean trans people have in some ways lost legal protection. He says they are still protected under our equality law. So obviously this case happened recently, and already within a few days of this case, we're starting to see the repercussions of this. So let's have a look at how this has kind of changed society in the UK and the policies towards trans people. This ruling sets a precedence beyond the Public Bodies Board of Scotland. So for example, British Transport Police have said that they are amending their strip searching policy after this ruling. So what this essentially means is a trans woman no longer has the right to be strip searched by a female officer and has to be strip searched by a male officer. So biological women have the right, or cis women have the right to be searched by a female, and this is obviously to protect from sexual misconduct and so forth. Whereas this right has now been removed from trans women. And beyond British Transport Police, there's also pressure on the NHS to update its policy on things like single-sex wards and excluding trans women and trans men from those spaces too. So Helen Belcher is chair of Transactual, a trans rights pressure group, and in this she says the statement where she states that trans communities are devastated by today's ruling. The Supreme Court chose not to hear from any trans people, preferring instead to listen to exclusionary groups. As a result, instead of bringing clarity, the Supreme Court has made a ruling which appears to contain a number of contradictions. Irrespective of the small print, the intent seems clear: to exclude trans people wholesale from participating in the UK society. Today, we are feeling very excluded. So this is despite the fact that Lord Hodge had tried to say, well, no, trans people are still protected, their protected characteristics under the Equality Act are still upheld and they are protected from discrimination. What she's saying here is, well, in reality, by refusing the definition of a woman to include trans people, you're excluding trans women from certain spaces. So she is correct here, though, that I don't think that this is the end of this ruling. There is potential for test cases here because this is so complicated and it's still quite mucky and difficult to kind of understand the difference between discrimination as a trans person and discrimination as a woman or as a man. So there could be more cases brought forward to the Supreme Court about exclusion and discrimination. So if a trans person is excluded from a space, for example, it would still violate their protected characteristics within the Equality Act. And it could come into conflict with those who are arguing that they are legally protecting a single-sex space. So this is an interesting case because we're seeing the complexity of UK law in trying to kind of protect everyone and where rights can sometimes come into contradiction with each other. So this is an important example to apply to your essays because it could fit into 3 or even 4 different parts of the A-level syllabus. For example, it can fit into pressure groups, looking at the actions of pressure groups and the debate to whether or not pressure groups enhance or undermine democracy. It can fit into constitution and understanding where power lies within the UK, as well as human rights as well, and trying to understand the kind of policy or the protection of human rights on minorities in terms of numbers, or minoritized groups in terms of people who have been historically denied rights as well. So it can also go under devolution as well, and looking at the kind of limits of Scottish power in the sense that the Scottish courts made a decision and that was then overturned by the Supreme Court, and how the Scottish courts and the Scottish government have agreed to respect the decision made by the Supreme Court. So what we're going to do, just to sum this up, is thinking about these 3 topics. We've got some points here about how this can be organised within the course. So can you organise this and think, how can we use this example to fit under each part of the specification? Okay, so this is how I've organised this, and you can kind of think about if you've placed it in different ways, why have you placed it, and kind of justify your decision. So how does this show that pressure groups are tyranny of minority and can actually undermine democracy, for example? So thank you for listening, and I hope you're able to use this effectively in your exams, and good luck.